In a dramatic clash between federal authority and local autonomy, a judge has temporarily halted President Donald Trump's plan to deploy the National Guard in Illinois, setting the stage for a legal showdown that could redefine the boundaries of military involvement in civilian affairs. But here's where it gets controversial. As Chicago and Portland grapple with this issue in separate courtrooms, the question of whether the federal government is overstepping its bounds or if local resistance has gone too far is sparking fierce debate. And this is the part most people miss. The rulings in these cases could set a precedent for how future administrations handle civil unrest, potentially reshaping the balance of power between states and the federal government. On Thursday, District Judge April Perry issued a temporary restraining order, TRO, blocking the deployment of National Guard troops from any U.S. state into Illinois. This decision, effective for 14 days, came after Perry concluded there was no credible evidence of a rebellion in Illinois and that the president could enforce federal laws without resorting to military intervention. She warned that deploying the National Guard would likely escalate civil unrest, requiring local law enforcement to respond. Perry also criticized the provocative nature of Immigration and Customs Enforcement, ICE, activities in the state, arguing that military involvement would add fuel to the fire. Meanwhile, in Portland, the Ninth Circuit Court of Appeals heard arguments on whether to lift a lower court's order blocking the deployment of 200 federalized Oregon National Guard members. Oregon's legal team argued that the deployment was part of a broader effort to blur the line between military and civilian law enforcement, based on inaccurate information about conditions in Portland. The state warned that allowing such actions could set a dangerous precedent, enabling the president to deploy troops in response to nonviolent civil disobedience nationwide. Here's the controversial angle. While the Trump administration insists that deploying the Guard is necessary to address sustained and widespread violent resistance, critics, including former military leaders, argue that such actions politicize the military and undermine its core missions. In an amicus brief, retired generals and admirals cautioned that domestic deployments risk placing troops in situations they're not trained for, endangering both service members and civilians. They also warned of long-term damage to military recruitment, morale, and cohesion. In Chicago, Judge Perry grilled Department of Justice lawyer Eric Hamilton on the scope of the Guard's mission. Hamilton described it as limited to protecting federal personnel and property, but refused to rule out mission expansion if circumstances changed. He pointed to instances of brazen hostility toward federal agents, including agitators bringing guns to federal facilities and attacking officers with rocks, bottles, and fireworks. However, Illinois' attorney countered that the situation had calmed significantly since local authorities implemented protest restrictions and state police began protecting ICE facilities. As these legal battles unfold, one thing is clear. The outcome will have far-reaching implications for federal-state relations and the role of the military in domestic affairs. But here's the question we're left with. Is the deployment of the National Guard a necessary measure to restore order? Or does it represent an overreach of federal power that threatens civil liberties? Let us know your thoughts in the comments. This debate is far from over.